You are there.
Yes.
Thanks.
To meet you.
Thanks a lot for coming.
Thank you.
So you can start, take the floor, and everybody, and ask everybody to sit down and to start. She will be online. Yeah.
Great. If I could ask everyone to take their seats, and we'll begin now. So, good morning. It's my pleasure and honor to open this third session this morning. In the first two sessions, we've looked a little bit about the history and the governance of the Schengen area without controls at internal borders. And now we turn to a question that is of important practical importance, and it's something that we deal with in our daily lives, which is the question of the actual identification of the legal framework, the identification to establish what exactly is the scope of the Schengen Acquis, and how do we decide what instruments are to be considered as forming part of the Schengen Acquis, and what are the consequences of that decision. So, and these important questions, which take up so much of our days, and sometimes our nights. So it's wonderful now to be in this position where we can step back and really sit together and explore and consider them. And we're joined by a particularly distinguished panel of experts to explore this together. So the first speaker will be Dr. Fabian Lutz, from the Commission and Director General DG Home, who's also been organizing this conference. And thank you again for the invitation. Dr. Lutz has been working in the Commission since 1996 and in migration policy since 2000, and has extensive experience, of course, in legislative developments relating specifically to migration and Schengen in particular. And particularly there, most recently, we were working together on the Schengen Borders Code amendments, and you were also involved in the Return Directive. In parallel, Dr. Lutz has written extensively in the field of Union and migration law, and currently he is on secondment to the European University Institute in Florence, where he's researching on Schengen-related areas and carrying out a fundamental job on mapping the Schengen Acquis. So we will then have two panelists who will explore and respond to the paper by Fabian Lutz. We have Elisa Ravasi, who is joining us remotely from Switzerland, and Peter Van Nuffel, who is beside me. Elisa is a diplomat at the Federal Department of Foreign Affairs of Switzerland. She's been working in the area of EU law and EU justice and home affairs since 2018, and is currently head of the JHA section of the Europe division there. So in this capacity, Dr. Ravasi has gained, and is there on the screen, so, and it's very nice to see you, has been working, has a very direct experience of the Schengen Acquis, but from the perspective of a Schengen associated country. Dr. Ravasi studied law in Zurich and also in Columbia Law School in New York, and her thesis was on the interaction of human rights law in the Union and the interaction between the ECJ case law in Luxembourg and the European Court of Human Rights case law in Strasbourg. And then finally, it's my pleasure to introduce my former colleague in the Commission Legal Service, Mr. Peter Van Nuffel. Mr. Van Nuffel recently retired as director of the Legal Services institutional team, having joined the Commission in 1983. And during his long career, he's worked in a range of areas, but is specialized on institutional matters and in matters relating to external relations. So Peter van Nuffel has been directly involved in a great number of treaty reforms, as well as the negotiation of the UK withdrawal agreement. He was appointed by 2 presidents of the Commission as their personal representative, tasked with working towards a settlement in Cyprus. So Peter is uniquely placed to consider the legal framework underpinning Schengen from an institutional perspective. So I will turn then, so I would give the floor so that we could start, and Fabian will speak on the subject of the scope of the Schengen Acquis, slim or large fit. I give you the floor.
Thanks a lot, Jonathan, and good morning. I'll speak about the scope of the Schengen Acquis. Is it mathematical precision or political flexibility? A bit on my personal context. As Jonathan mentioned, normally I'm working for DG Home Affairs, but I was lucky enough to escape now for 1 year to Florence, to the European University Institute, and to focus there on a research project on Schengen. And in the context of this Schengen book, which I'm drafting now, I focus particularly on the scope of the Schengen Acquis, trying to understand what was the scope of the Schengen Acquis and how it developed and why it was defined in the way in which we find it today. I based myself on literature, legal documents, and I also harassed, I think, a lot of people who are in this room with research interviews. So I made an attempt to reach former officials of Council, Commission, Council Secretariat, Schengen Secretariat, and asked them some questions for which I didn't really find replies in literature. So the results of these interviews with Schengen veterans, I will also partly reproduce them here in my presentation because I find them really interesting. The presentation itself, I will focus on the history, how the Schengen Acquis developed, then describe status quo, and then have some ideas on further developments. Briefly, the history, we all have heard about it already. 1960-62, we had the Benelux Convention and the Benelux Treaty on judicial cooperation, which indeed, as was rightly said before, provided substantive input. So I was always wondering, where does the distinction between short-term stay, long-term stay come from? Where does this 90 days rule come from? If you want to know it, look up in the Benelux Convention. There is the same wording than the wording which was then later used in the Schengen Convention. The same applies, for instance, to the hot pursuit. The rules on hot pursuit, they were already in the 1962 Benelux Treaty on judicial cooperation. So I don't say that everything was copy and paste, but many elements were indeed taken from these Benelux conventions. This was, however, the Benelux context, and then came the political trigger, what we heard today, Chancellor Kohl and Mitterrand first agreeing in the Saarbrücken Agreement and then in the Schengen Agreement. Yes, so what has been done in the Benelux context, now we do it on a broader European level, we do it together. These were policy declarations, soft law, and the real legal backbone now of Schengen law was indeed then the 1990 Convention implementing the Schengen Agreement, which defined the substantive scope of Schengen. Substantive scope of Schengen, as you find it now in this agreement, consists of a core measure, so lifting of internal border control, external border control, visa, that's the real core, plus a number of flanking measures to facilitate, to make it possible. This choice of the flanking measures, what I find also was not really, there is no sort of a mathematical law which says that in an area without internal border control, you necessarily need these 11 flanking measures, 1, 2, 3, 4, 5. But there are lots of flanking measures which are helpful in the context of an area without internal border control. And the exact measures which were put into the implementing convention were also the result of political negotiations. So there was the Schengen logic. There are no internal border. We need some other fields where we have harmonized policies, but at the same time, there were also political choices, which subject matters to include and which not to include. It's important to know that because, for instance, I always wondered before, why is immigration and why is substantive asylum law not covered by the Schengen Acquis? Well, the replies which I got in these research interviews was that some told me, well, we simply thought it was too complicated. If we had tried to harmonize that, it would have been a never-ending story. So we just focused on the short-term stays, and for the long-term stays, we decided to leave it up to member states. But of course, you could easily argue that immigration is also Schengen relevant, because if one member state is regularizing irregular migrants, hundreds of thousands, and they move on to other member states, it is of Schengen interest. The free movement rules. Free movement rules, as Monika Moshammer always reminds me, is so to say the dog and Schengen is the tail. It's not the other way around. So free movement was really the business basis for Schengen. Free movement as such was not Schengen Acquis, is not Schengen Acquis. It pre-existed Schengen, and Schengen somehow was a tool for making free movement a full reality in the EU. And any Schengen Associated State must comply with the free movement rule as a precondition for even being Schengen Associated. That's a political understanding we have. Some of what we think today are hot topics today in our political reality were not yet hot for the 5 signatories in 1985. Therefore, for instance, you don't find anything in the Schengen Implementing Convention on solidarity in situation of migratory pressure or responsibility for irregular migrants. I also interviewed Jan de Köster, whom many of you know, and he said, if Schengen would have been negotiated today, of course we would have something on frontline member states and solidarity. But at that time, it was just 5 states and the geopolitical situation was different. So there was no really frontline member states involved at that time. And other measures were regulated in a manner which we really don't understand today, so that the responsibility criteria for the asylum seekers, which were then reproduced in the Dublin Convention, were designed in the migratory times of good weather. If they would have been designed today, they would look completely different. So it's also important to understand this. Also, what's important to know, contrary to what many academics say, freedom and security always coexisted in Schengen from the beginning. It's not that in the beginning Schengen was just about freedom and then it became an issue of security after 9/11. No, both coexisted from the beginning. The driver of Schengen was always the free movement of their own citizens, and the free movement of third country nationals was an ancillary component which was necessary to realize free movement, but was not really historically a self-standing objective. And it's also true what many say, that in fact, but it's a historical reality, 5 states, the 5 signatory states, designed 35 years ago rules which are today applicable, more or less unchanged, as some have changed, to all member states, including the Dublin rules. Article and 42 of the Schengen Implementing Convention, they are very important because they say that whenever something is regulated by the European communities, or if there is a convention agreed by all member states, then this subject matter loses its Schengen character and becomes normal union, EC law at the time, or union law today. So the underlying philosophy was Schengen was set up as a laboratory. It was necessary to set it up in an intergovernmental form because the UK and Thatcher, they were not willing to participate. So the only way forward was to have this laboratory. But whenever something would been agreed, it's convention binding by all member states, then these measures would lose its Schengen character and become part of EC law. So the philosophy behind was that gradually Schengen should cease to exist and all subject matters should be involved in the evolving EC and GHA acquis. We have some examples. I've listed them here of this, what I call the lost children, I nicknamed them, the lost children first generation of the Schengen Acquis, where I see that some articles of the Implementing Convention were already replaced by EC acts before 97. The most prominent example, the responsibility rules on asylum applicants, which were replaced by the Dublin Convention. Then there was the Big Bang, 99 Amsterdamization, the treaty plus 3 protocols, the Schengen Protocol, the protocol on Denmark and the protocol on UK, Ireland, plus the simultaneous Schengen Association Agreement with Norway, Iceland, which were then implementing by these Council decisions 435, 36, 37, which remain very relevant and important until today. These Council decisions laid down the nitty-gritty details. Some are defined what is the Schengen Acquis, what's the legal basis, and which criteria should we apply in the future when discussing new developments of the Acquis. When should we consider it Schengen-related or when not? Some academics have commented, and I think there is a grain of truth in it, that what happened in 1999 was in fact that one sin, namely the intergovernmental sin, was replaced by another sin, namely the sin of variable geometry. Why do I say it's a real sin? This variable geometry, the variable geometry required a change of philosophy. Before 1999, as I said, the scope of the Schengen Acquis was flexible and was gradually reduced and integrated into EC law. Since 1999, it became static or frozen. There was a creation of two new worlds. We had the Schengen world, based on the Schengen Acquis as defined and the further developments. And simultaneously, we had the broader GHA world, which was then developed on the basis of the Tampere conclusions. And the finality of merging the Schengen world with the broader justice and home affairs world was left aside because of the protocols. The protocols made it clear that when something is Schengen related for Denmark or for UK, Ireland, specific rules apply, also for the Schengen Associated States. And when something is justice and home affairs related and not Schengen, other rules apply. So it was really necessary to maintain this, you may call it artificial distinction, until today. I mean, I know that, for instance, today in the introductory statements and then also in two subsequent interventions by other speakers, many have a tendency of now merging justice and home affairs with Schengen. So in reality, it is one world. But legally speaking, these are, until today, two different worlds, and we are doomed to maintain these two different worlds until something is changed. And next to it, there was also an absence of mathematical precision in the legal frame agreed in 1999. So, for instance, there is no precise indication what should be done with the first generation of the lost children, firearms, visa format, Dublin. Several approaches were followed. Some were labeled not Schengen related, and subsequently they were again labeled as Schengen related, or Dublin was labeled as closely related to Schengen. So the Schengen Associated States had also to conclude Dublin agreement, but Dublin itself was not called Schengen. There was uncertainty whether the criteria fixed in the decision 437 apply only for Norway, Iceland, or whether it defines more broadly for also vis-a-vis Denmark, Ireland, and Switzerland. And there was a resulting uncertainty whether there are different concepts of Schengen relatedness or just one. Do we have Schengen Acquis just within the meaning for Denmark or the UK, Ireland, or for Associated States, or is it one global concept? The court, in my view now, and also the practice governed into the direction that it's just one concept of Schengen relatedness. And there was also uncertainty as to whether a legal act can be Schengen related and non-Schengen related at the same time. What something is this legal monster of a hybrid legal act. So all these issues lead to persistent legal debates, which are haunting us until today, as also the chair may be able to confirm. In practice, after 1999, the determination of the Schengen Acquis and Schengen relatedness became, for these reasons which I outlined before, a rather political than a substance-based decision. And the leading role in defining whether a new proposal, a new act in a field previously covered by the Schengen Acquis was Schengen related or not, was taken by the Council and its legal service. And there was a very important document, which I quote here, on a co-repair doctrine on Schengen relatedness, which sets out a rather, as I call it, minimalist doctrine. So only those measures which are very absolutely essential in terms of the realizing an area without internal border control should be labeled as Schengen related, and the rest should not be labeled as Schengen related. And as a consequence of this approach, some parts of the acquis which were previously Schengen related, such as police cooperation, legal assistance, readmission, and many others, became just normal union law in which the Schengen Associated States don't participate. That's what I call the second generation of the lost children. So, and I was really curious to learn what was the reason for this restrictive line. What were the arguments? Because legally you could equally or even better have argued in the other way and say everything, the topics like extradition, which were covered by the Schengen Convention, should also be now the European arrest warrant to replace it should be labeled as Schengen related. Why did this not happen? The replies I got were consistent insofar as they all said it was a political decision, but the reasons which I got were different. So in essence, there were 5 groups of reasons. One main reason seems to have been that there was a political wish to allow the UK to participate. So I think there was more interest to have London about than Reykjavik. There was a wish to prevent non-member states, so Norway, Iceland, and then Switzerland from joining the broad GHA field without becoming a member state, not allow them to be sort of free rider. Then there was an interest of accelerated decision-making, particularly after 9/11. So the procedure in the mixed committee seemed too slow. So again, European arrest warrant that was probably an important consideration in that context. Then there was also the idea that this principle of mutual recognition, which came from the Tampere agenda and which was different from the cooperation agenda in Schengen, this mutual recognition should be applicable to member states only. It seems that France had a very strong point on that. And there was also an interest to limit the number of legal acts which might be applied only on installments under the 2-step approach, which is applicable for the new member state, because at that time it was 10 new member states were more or less waiting in the pipeline, and one wanted to avoid to have too much acquis to be made applicable on installments. So where do we stand today? Is the Schengen Acquis a coherent ensemble as referred to by the European Court of Justice in its 3 judgments, or does it rather look like an onion? For me personally, it rather looks like an onion. The onion is characterized by the inner layers, by outer layers, and by the aura. So in the inner layers, you find those measures which are really undoubtedly Schengen Acquis, internal, external border, visa, and so on. I mean, no one has doubted these are Schengen Acquis. In the outer layers, we have some questions. Return, hybrid. Document security, mainly Schengen, but not document security for e-citizens. Irregular migration, 50-50. Dublin asylum seekers, not Schengen, but a strong link through the Schengen Association Agreement. So Switzerland, if Switzerland drops the Dublin Association, it must also drop Schengen. Police cooperation split into Schengen and non-Schengen part. Judicial cooperation split into Schengen and non-Schengen part. Drugs, simultaneously, the Schengen article is still surviving, but at the same time, EU acquis applicable, which doesn't apply to the Schengen Associated States. Firearms, sometimes labeled as EEA acquis, later on again labeled as Schengen acquis, and data protection also split. And amongst these outer layers, then we have the aura, what I call the aura. These are policy fields which are very important and relevant for Schengen, but which are formally not labeled as Schengen related, namely asylum, free movement, for the reasons explained, this is already the business basis, readmission, solidarity measures, and responsibility for irregular migrants. For the agencies, out of the 8 GHA agencies, only 2 are Schengen related, namely Frontex and EU LISA. Even though EU LISA is also a sui generis hybrid agency, which is quite a complicated legal constructions to make sure that all member states apply. And all the other agencies, they are labeled as not Schengen related. However, as you can see here, nevertheless, the Schengen Associated States and also Denmark, in most cases, managed to participate in the work of these agencies through separate bilateral operational agreements or working arrangements. So the fact that you make a legal act not Schengen related does not mean that the Associated States and Denmark are necessarily excluded. So what is the status quo now of this acquis as we find it today? I think it's characterized by legal complexity, and the legal complexity has become a real plague for all of us. It consumes time and administrative resources, need for parallel proposals, need to split the proposals, parallel agreements, and not to speak about the international relations. So when we have visa facilitation agreements, visa waiver agreements, this variable geometry causes a lot of problems also for our international partners to understand. The complexity delays the political decision-making. The best example is the recent debates we have between the legal services of the two institutions on the legal basis of the pact. There is a 40 pages council document and the Schengen relatedness of the pact proposals, which show that, I mean, the argument about the Schengen relatedness or not may really hamper political decision making. And it also undermines the legal certainty. So, for instance, until today, all attempts of the Publications Office to produce a consolidated version of the Schengen Implementing Convention failed because things are so complicated and there's so many layers. Myself in my research, now I try to produce a version and it really took me 3 weeks and a lot of footnotes and very creative footnotes to describe what is the current applicability of certain CISA articles. Some articles, they remain, have been superseded for the Union, but remain in force vis-a-vis Schengen Associated States with a limited time until another convention enters into force, for instance, in the extradition field. So and some conventions have still to be ratified, old third pillar conventions still have to be ratified by member states and only entered into force in 2016 or 19. So it's an incredible legal mess if you go into the details. So I put it short, we are faced with a considerable legal complexity. So outlook, options for reducing complexity, how can we get out of this situation or at least improve it? Again, in my interviews, I encountered more or less 3 schools of thinking. The first school of thinking was the pragmatic one. Accept the historically grown situation as it stands today. We have to live with these complex legal situations. Any attempts to change it will fail anyhow. So let's simply, that's why there are lawyers. Let's try and manage somehow this school of thinking, which is not very satisfactory from my point of view. The second one is arguing for broadening the concept of Schengen relatedness, reorienting itself on the scope of the Schengen Implementing Convention, notably in the post-Brexit landscape. And this could be sort of a partial approach that, let's say, at least for instance, in the field of police cooperation, where there is the hugest mess, I would say, between Schengen-related and not Schengen-related measures. We agree on a more consistent labeling of the measures as Schengen-related, which would then have the advantage of allowing the Schengen Associated States to participate directly. Denmark could also participate under its current protocol, since it can participate under international law and anything which is related to Schengen, and there would not be this need for bilateral agreements with these states. And then there is this third and maximalist position, and I understand one of our panelists is also somehow find some charm in this solution to really abandon the concept of Schengen Acquis and treat Schengen Acquis like normal union law. This would require a change of primary law, but it would make some sense because, as I explained in the beginning, the two worlds have grown together. Schengen and GHA, it's very difficult to keep them separate apart. They are one coherent, or should be one coherent body of law. However, it's a problem. What do we do with Ireland? What do we do with Schengen Associated States? So one would need to be creative. For Ireland, one could think of a sort of a permanent derogation on the relation to internal border control, common travel area, a little bit like Cyprus with the Green Line. One would have to be creative, but saying that a thing is difficult doesn't mean that it's not feasible. So at least I think this option is worth looking into it. And I'm already coming to the last slide now. How to proceed. So what could we do, in fact, to operationalize now further considerations to change the situation? So what the interview partners said, that they all agreed that the Brexit and the departure of the United Kingdom provides a window of opportunity now to sit together and have a horizontal assessment on what should be Schengen related or not. So we should go away from this piecemeal approach that each time a new proposal comes to the table, first the Commission Legal Service, then the Council Legal Service, then in Council and Parliament that this issue becomes debated, and normally it's very emotional. You get the red faces and saying, I am right, now I am right, how could you misunderstand it? So we should really try to avoid that. Such Schengen reflections could be carried out. That was a suggestion which was made jointly by Council, Commission, and the most affected states, so Denmark, Ireland, and the Schengen Associated States, and other interested states, in a sort of Friends of Schengen group, Friends of the Presidency, whatever, sitting down together, seen an e-rights studio, and see if there is common ground for a new approach. And based on such a political agreement on the line to follow, maybe It was suggested a clarifying council decision, like in 1999, might be proposed, together with an omnibus proposal, declaring as Schengen-related or not Schengen-related those legal acts which would fall under the scope of this renewed understanding. And as a complement, maybe a more far-reaching long-term perspective involving a change of primary law. So the Schengen protocols and the other protocols could also be developed and recommended and be kept in the pocket if one day there is really a chance for changing primary law. Thanks a lot for your attention.
Thank you very much for this very clear and comprehensive analysis. And in particular, thank you for, well, first for the image of the onion and the two worlds, which will stay with me. And thank you also for not just identifying the issues, but actually pointing to some possible solutions, some possible ways out. So maybe what we'll do next is, so we have our two panelists who will now explore a little bit from their perspective the issue outlined by Fabian, and maybe also perhaps react to which of the options, which of the solutions, if any, that they would justify or they would favor. So I would now give the floor then to Elisa. Over to you. Thanks.
Thank you, Jonathan. Can you hear me in Brussels?
Yes, perfect.
Fantastic. So good morning to everybody in Brussels and online. First of all, allow me a brief disclaimer. Everything what I say today is in my personal capacity and does not necessarily reflect the position of the Swiss government. This put aside and being said, let me start with a short historical context of the Schengen Association of Switzerland. The negotiation of the Schengen Association Agreement were concluded in 2004, and the agreement entered into force in 2008. Negotiation is a big word, because actually what happened was that we copy-pasted the Schengen Association Agreement of Norway and Iceland with very little margin of maneuver to make minor adaptation. This means that the legal framework that were agreed in 1999 or decided in 1999 after the Amsterdamization of Schengen are actually valid also for us, and we received them as a package. It was never really a discussion on a best way to define Schengen in Switzerland. This reality also influences our view on the decision to determine whether an act is Schengen related or not. In principle, we consider this decision to be an EU internal decision on which we exercise a lot of restraint, and we very rarely take a position on this question. There are two exceptions to this restraint. First, if we are asked about our opinion, that was, for example, the case with the possible Schengenization of parts of the Pact on Migration and Asylum after the opinion of the Council Legal Service in 2021. Or last year in spring, when we were brainstorming about a possible Schengenization of Prum 2, which never saw the light of the day as long as I'm informed. The second exception to our restraint is when we need the risk of major incoherences. A recent example for that was last fall, the decision on the non-recognition of Russian travel documents issued in occupied foreign territories. On a principle, no problem at all, of course, but there was the risk that the national competence of the recognition of travel documents could have been Schengenized almost or transferred to the EU with these acts, depending on its formulation, and there we intervened along with other member states, and it was changed that and specified that this kind of competence was not Schengen or Schengenized. However, what we have witnessed in the past 15 years of Schengen Association is an ever-growing complexity in the Schengen Acquis construction. The area of justice and home affairs, as already Fabian explained us very well, is as much intertwined within itself and with Schengen that a clear-cut separation of what is Schengen Acquis and what is legally binding for Switzerland because of the Schengen Association Agreement is becoming more and more difficult to separate from other EU acts. A concrete challenge we have during every negotiation of Schengen Acquis development is how to deal with references to non-Schengen related acts in a Schengen related act. Indeed, the simple reference to a non-Schengen related act does not make it binding on Switzerland. This wouldn't make any sense, and it would pose major legal and then democratic problems. That we still have an interest to ensure a coherency and a harmonized working of the Schengen area and well-functioning of this cooperation. So what we usually do as Switzerland is to work by analogy and to find national or international legal acts that are applicable to Switzerland that cover the same area or have the same purpose as the references to non-Schengen legal acts in Schengen Acquis. I'll give you two examples because otherwise it becomes way too abstract. GDPR. GDPR is non-Schengen. However, I think almost every Schengen Act refers to the GDPR. What we do in Switzerland is to refer to the adequacy decision of the Commission that recognized the data protection of Switzerland as adequate or equivalent to the one in the EU. And we consider that our national data protection laws cover also GDPR references. We can just ignore that the adequacy decision of the Commission dates from 2000. We are expecting an updated decision very soon. A second example is PRIM. A less widespread challenge, because there are less Schengen Acquis that refer to PRIM than to the GDPR. However, we have been lucky enough to conclude an agreement with the EU to participate on certain part of the PRIM cooperation, so that we interpret references to PRIM as being covered by our PRIM agreement, which, as a side note, entered into force only in March this year. However, this pragmatical unilateral solution is not always possible or applicable. I give you two more examples of challenges we are facing right now. The first one regards a reference to the EU-UK withdrawal agreement that was found in a proposal for a regulation on the digitalization of visa procedure last year. Switzerland did conclude agreement with UK after Brexit in order to ensure the legal continuity of rights and obligation. But we noticed that in this concrete case, there was a difference of treatment for, wait for it, third country national family members of UK citizens, depending on the case if they were living in Switzerland or in a member state prior to Brexit. We could wonder how many people are really concerned by this specific possible discrimination. We are still discussing a solution on that. Another example is relates to the Firearms Directive. There are two delegated acts based on the Firearms Directive. They are Schengen related, and they foresee information exchange by means of the Internal Market Information System, a non-Schengen system to which Switzerland does not have access. This means currently that as long as Switzerland does not conclude a supplementary agreement that gives its access to the EMI system, we are de facto excluded from this Schengen cooperation in the firearms area. These examples show that the legal complexity and the intertwinedness in the area of justice and home affairs pose serious legal and practical challenges, especially for Schengen Associated country and then Switzerland concretely. I therefore very much share the assessment of Fabian Lutz regarding the untenable complexity of the Schengen Acquis that would be need to be solved at a certain point. This brings me to the outlook and the option that have been mentioned to reduce this complexity. As a matter of principle, I consider any efforts to decrease complexity and improve legal certainty to be a very positive undertaking worth to be supported. I'm also convinced that the broadening of the cooperation, of the Schengen cooperation to other fields of the justice and home affairs would be in the overall interest of the well-functioning of the Schengen area, as well as for all people in Europe. Indeed, the Schengen Association has been proven to be a success story for Switzerland and the Swiss-EU relations in the past. However, there is always an however. On a formal legal perspective, the ex post Schengenization of certain legal acts would require the possibility of some form of opt-out, concretely for Switzerland, but probably not only, in order to compensate for the lack of decision-shaping rights in the legislative process. I'm aware that this goes against the idea of making things easier and more coherent, but the Schengen Association Agreement builds upon a very delicate balance between rights and obligation, which enables the dynamic nature of this agreement and cannot be one-sidedly altered. Also, we could consider that broadening the Schengen scope and then Schengen cooperation would probably necessitate a renegotiation of the Schengen Association Agreement, which I know that compared to a possible treaty changing process, it seems like a legal thing. But from a Swiss perspective, in the current European political climate at national level, it may be an adventure that one would prefer to avoid. Hence, there may be a good reason why so far we have preferred to pragmatically muddle through the legal complexity of the Schengen Acquis rather than trying to make them more solid and then sound with a whole-encompassing reform. However, that is how the European integration has always worked, and it is no reason to strive for a better solution. On this note, I give you now back the word to Brussels, Jonathan, and look forward to the discussion afterwards with the public. Thank you.
Thank you very much indeed for that. And now I would hand the floor over to Peter van Uffel.
Many thanks. Good morning, everybody. I also want to thank the organizers for inviting me. Although I'm retired, this has given me the opportunity to walk around with the treaties again, as I did for more than 30 years. It feels really nice in the hand to feel the book, the treaties again, and so I'm in a very positive mood. I wanted to today react on, compliment rather, Fabian's expose on 2 points. The first one is on how this is complex, yes, but how did we get there? Or rather, why did we get into that complexity? Perhaps we may have had today another complexity, but I wanted to go briefly into why do we have this complexity? And the other one is a few comments, as Elisa did, on the outlook, what could be done. So on this first point, how did we get there? First of all, I wanted to say as a kind of introductory remark that we should all think about how amazing this Schengen development was over the years. You cannot imagine today how it was in the 1980s. I mean, especially the younger ones here around the table. It was nothing of all that. There was no judicial cooperation, no police cooperation. There were a few international agreements, some Council of Europe agreement, was all. It didn't exist, and the EU had no competence. Now, it can be a debate. There was in the treaty, the article at the time 235, which is today 352, which gives the Council the opportunity, the possibility to act with unanimity. And some said you can use it for that purpose if we have the right objectives, but member states didn't want it. So as a practical point of view, no competence. And this translated into the Commission as follows. In 1985, I joined a unit which was called l'Europe des Citoyens, Citizens Europe. And it consisted of one head of unit and 3 desk officers. Was all. So the whole area, what you're talking about, was dealt with insofar as the Commission had to deal from time to time with such matters by these 4 people. If you compare that with DG Home and DG Just together, it's more than 900 staff, I understood. So that is the enormous explosion which has happened in these years. And this is the whole, essentially, Schengen, but of course also the broader GHH environment. Now, how did we get into this complexity? It was, of course, the Treaty of Amsterdam, where this has all been done. You have to look at the timeline. So we have the Schengen Agreement 1985, the Convention signed in 1990, entered into force in 1995. So when the Amsterdam, when the intergovernmental conference started, which led to the Amsterdam Treaty started, this was all ready. And the mood was for integration of Schengen into the EU. As of course in these treaties, it's mentioned everywhere that the aim should be that this is simply a laboratory and it should go to the EU. There are many examples of there was a Westendorp group which looked in the matter and said should be integrated, Commission opinion, member states' interventions during the conference were clearly for an integration. That was not the point. The point is, how do we integrate? And I think in the slides Fabian showed, you could see that in fact the Schengen system, the convention itself, had developed another model. When you refer to Article 134 and 142, it was that Schengen should kind of disappear and should be overtaken by EU law. That clearly that kind of way didn't happen. Now I looked up a little bit old papers, which I don't have, but you can find them in website. And there is a paper of the Dutch paper of July 96, a year before the signature of the treaty, which says incorporation of Schengen, a forced incorporation is not advisable. There should be a three-stage approach. First, practical cooperation, location of the secretariat with the institution, then transfer of policy preparation to the institutions, so, but keeping the Schengen Acquis separate from the EU Acquis, and then in third stage, a full incorporation. And then interesting sentence is, the Schengen Acquis will be conversed/transposed into EU regulation. That's what the Dutch government proposed at the conference. So there were further discussions. I have no papers on that. But the following step is from March 97, 3 months before signature, whereby a presidency paper, so which kind of brings together the state of the discussions, simply said Schengen should be integrated. It would be incorporated, and then the main words are as it exists. And it emphasizes more. So as it exists from the very moment of entry into force of the treaty, instead of readopting it under the corresponding new treaty provisions. And then it explains, therefore, excluding any possible renegotiation of that legislation under the new treaty. I think that is a main element of why we are here in this complexity. This was to avoid renegotiation of what Julian Suter and others had painfully done between 1985 and 1990, between 5 states, don't forget, between 5, or rather between 3, not 3 states, but 3 groups. Side remark, we talked this morning about Benelux. It's very interesting to see that both the agreement of 85 and the Convention of 1990 are concluded between France, Germany, and the governments of the states who are the Benelux Economic Union. So these are the 3 parties, although there had to be 5 for ratification and so on, because Benelux has no external relations competence. So that is, in my view, the major point. That is, at that stage, they wanted to have it integrated as it exists, no renegotiation. What we done with the 5 of us was very good, and it should remain like that. And then 2 months later in May, so 1 month before the end, you can already see in the president's documents the whole protocol. And there is the notion of the closer cooperation which comes in. And why did they look at the form of a closer cooperation? I have no real explanation than that, but simply it was in the mood of the time. Amsterdam Treaty brought in cooperation, and many people thought this is a way forward for the European Union as a whole. So we like this idea of closer cooperation. Now, with hindsight, we know how little it has brought and how complex it can be, such close cooperation, whenever they never can exist. But at the time, there was enthusiasm for that form, so they went for that rather than the opposite. That is to say, we make it union law, and we have some protocols opt-out, opt-in, whatever, for the one or the other. So these are, for me, the reasons. Another reason also, doubtless, is the fact that the agreements with the 5 countries of the Nordic Passport Union were signed, and that the position of the Associated States, Norway and Iceland, in Schengen is much stronger than typically association agreements which you can have. And I think the last one is that something typical. I've been in many intergovernmental conferences, that is, worry about complexities later on in the political world are zero. They are not worried about complexity then, they are worried about having an agreement now and making some text you can defend and possibly have to defend in referendum and get that through. Right? If I have still time, I would like to come to the second part, that is a few additional comments on the 3 ways Fabian has sketched for options for the reducing the complexity. First, accept the situation. Well, I'm quite certain everybody here is totally in favor of reducing complexity, but I should warn, with say my experience as from IGCs, that it is only a legal complexity. It has no real consequences. Well, it may have some real consequences in timing and so on, more discussions, but in the real world, nobody cares. And it is no, I mean, we have to be frank, and it is very unattractive for the political world to spend political capital on undoing a complexity which is purely a legal complexity. As you said, we have our lawyers, they are paid for that, they can solve it. So the world can go on. And indeed, the lawyers, they do it. They make opinions of 40 pages if requested. So I'm not in favor of that solution, but I think we have to really keep in mind that it will be difficult to do something about it, because it requires from the political world to invest political capital in something where they cannot show to the citizen why you are doing this, why we are. On the question, on the point of broadening the concept of Schengen Acquis, of the Schengen relatedness, I remain a little bit puzzled, because it has been done, for better or worse, in 1999 and so on. So this whole also acquis, legal acquis for 25 years, how can you do away with that? I understand Fabian's argument that a lot of decisions why yes or not it should be included in the Schengen Acquis was politically driven, but coming from a legal service, nevertheless, I would like to insist that they were always based on a legal analysis. Now, legal analysis, you can have different ones and you can come to different conclusions, but it's not so easy after 25 years to simply say, you know, we have a treaty provision which says, is it Article 5, proposes initiatives to build upon the Schengen Acquis, to simply start to have another definition of that. So there again, I'm not convinced that we can simply do this if even if the political will be to have a new, really serious new definition of what a Schengen Acquis could be. And a footnote there is also, would it also not simply be moving the posts? Okay, we would have a more broad Schengen Acquis, but still there would be a part of the justice and home affairs world which would be outside. So we would continue with complexities. Is the whole thing then worth political effort to do that? Worthwhile for moving posts? Possibly, yes. But I mean, as we are here discussing, this is the thoughts which come to my mind. As the last one, abandon the concept of Schengen Acquis. As Fabian said, yes, I'm very much in favor of that. It would, in theory, be extremely simple. We delete the Schengen protocol. We make another protocol dealing with the situation of islands, saying that they should not apply whenever they have problems with their common travel area. Perhaps a sentence for Cyprus to note that they still have the Green Line there and might apply other things. I hope that at some time, Denmark would come to reason and or it's not so much to reason, it's more that the political world in Denmark can convince its citizens that they vote in a referendum to abandon their protocol. But at the same time, we must all see this requires treaty change, and treaty change is for the time being impossible. And in the envisageable future, that is a few years, but the time may come. And if the time comes, I think everybody who is a friend of against the complexity of Schengen should be ready to put that on the agenda of the IGC of treaty change. But for the moment, this seems very difficult and politically. Another difficulty or another consequence would be when we do away with the Schengen Acquis is that the relations with all the associated countries would have to be looked at again new, to ask the EEA countries what exactly should be the association you want with the European Union in the area of justice and home affairs. Not this kind of Schengen, which is imposed upon you, but what should really be the association? The same with Switzerland. How far should it go? So this is also a complex thing, and I think Elisa already referred to that putting a new structure for the European Union for the whole Schengen would require new discussions on really what topics they and we want association in these matters. I think I'm done with my comments. Thank you.
Thank you very much to both our panelists. It's been really fascinating to hear more about how we got to where we are, and also to hear the perspective of a Schengen associated country of the impact of the decisions that are made. So we're now on time, and we have a chance to listen to your comments and to discuss. So, and I see already a couple of hands. So maybe we'll take a few questions as a round, and then we'll reply like that, if that's okay.
And just share a practical information. As you see, there is no lunch on the program, so it means that we are going to continue the discussion till 2 o'clock and then go on. But no, more seriously, there is a lunch foreseen around 1 o'clock. So we have a little bit less than 30 minutes for this discussion.
Right. And again, the only request would be to keep questions relatively brief, so that we can get as many questions as possible. Okay, so, and I see there's already one question there from Timothy.
Yes, hello. Thank you very much for your presentation. I must say I was a bit surprised, Professor Lutz, with your presentation insofar as we're talking about a legal subject, and I didn't see the case law of the Court of Justice. So I was wondering, I suppose that you know about it, but I was wondering what you thought about the test that has been developed in some case law by the Court of Justice, which looks a bit like the test of the legal basis, so objective factors amenable to judicial review. Do you think that the Court of Justice is trying to take it from the political arena in order to make it a more substance-based test? Thank you.
Sorry, yes.
Yes, thank you very much for the presentations. Very, very interesting and stimulating. My question relates to the two exceptional cases, the case of Ireland and Cyprus. Now, in Ireland, we have an international border which the Republic of Ireland eventually wants to do away with. So it wants to soften it. So the checkpoint, there the situation with Schengen requires something. In the case of Cyprus, we have a division which is not a border, which one country wants, Turkey wants to make it a hard border, and the Republic of Cyprus doesn't want to make it into a border. Yet we hear the example of keeping the exception of Cyprus as they are in place as a way for the future. And we also heard from Professor Lutz being sort of more positively inclined to thinking around the complexities using creativity, using Cyprus as the example. I'm wondering what your thoughts are, given that there has been some sort of triumphalism about Cyprus eventually joining, although there is a point in the decision that says until checks at internal borders with Cyprus are lifted. So there is this idea that as long as the Cyprus problem continues, it won't happen. I would like your thoughts on these two cases and how these affect how we understand the simplification and integration further of in the case of Schengen for Cyprus. Thank you.
Is there a third question? Or should we? Oh, sorry, great. Thank you.
Thank you very much. Sorry, I was hearing myself. Many thanks for these thought-provoking and very interesting presentations. I am very interested in what you explain, Fabian, Lutz, about the external relations perspective and the effects of this Schengen relatedness. I have worked on that. I find it very interesting. And I was wondering how to manage the legal effects of the two options you were referring to, broadening the Schengen relatedness concept or completely abandoning even the concept. From an external relations perspective, I think there was this remark about how, well, the association agreements to Schengen would probably need to be renegotiated. But I was wondering also about the existence of, that would mean we would have old and new international agreements with third countries with different territorial scope of application. And how, well, a visa facilitation agreement, which is a Schengen-related instrument, cannot accept now an opt-out Schengen country, but the EU readmission agreement, which is related to it, accept it, although because this is not a Schengen element, a decision in which I think many political elements got weight, because readmission was in its origin a Schengen concept. So that would mean that these agreements would change nature and they would have different territorial scope. We accept that in external relations in Schengen, that we have to admit very complicated negotiations for these purposes, but what about having the same agreements with different countries and different territorial scopes? Would that complicate even more the external action of the EU? Thank you.
Right, so perhaps then, shall we begin with these three questions? So one about case law and the relationship between legal and political considerations, the special situation of Ireland and Cyprus, and third, and variable geometry, and third, the external relations perspective. Fabian?
First, on the ECJ case law, there is relatively limited case law on the scope of the Schengen Acquis, the notion of the Schengen Acquis. In essence, there are these three cases concerning the UK request to participate in specific instruments, notably the Frontex regulation, to make sort of a piecemeal request to participate, which the Council rejected, and then the case was brought to the Court of Justice, and the Court of Justice said rightly, I mean, if a member state, according to the UK-Ireland protocol, the Schengen protocol, wants to participate in parts of the Schengen Acquis, it must take part in a coherent section of this Acquis and cannot simply say, I want to participate in legal act A, B, C, but not in D, E, F. So, and the court very much underlined that the Schengen Acquis is a coherent ensemble. But these cases then were mainly related to the participation of UK and did not dwell upon the issue about whether, for instance, the European arrest warrant or other what I call the lost children of the second generation, all these police and judicial cooperation instruments, which were labeled as not Schengen related, even though they replaced provisions of the Schengen Acquis, whether this is justified or not. Probably because such a case never arrived at the Court of Justice. I found in my historical work interesting documents that when the European arrest warrant was negotiated, Iceland was quite furious. Iceland protested, sent a letter by the minister and said, we always assumed that we participate in Schengen. Schengen implementing convention contains extradition. Now suddenly you tell me that when we're negotiating a new extradition instrument, I cannot take part. I'm really opposed to that. But Iceland was more or less ignored. A European arrest warrant was adopted as a not Schengen-related instrument. Iceland could not participate, but also Iceland could not bring the case to the court because Iceland had no standing. And other member states were not really excited about this problem. So probably if the case would have gone to the case of justice, I think the case of justice, Court of Justice would have found that it's not justified to label the European arrest warrant as not Schengen related. I mean, this is my very personal impression. And this is also related to the well-foundedness of one of these three council decisions. You remember the three council decisions I mentioned from 99. There was the third one, 99-437, determining the Schengen relatedness for purposes of the Norway-Iceland Association Agreement. If you look into this council decision, and this council decision, by the way, was done without commission proposal and without involvement of the parliament. So the Steve Peers, a very critical academic, criticized this practice, as he called it. I mean, it was the final orgy of non-accountability of council, which I, of course, don't share this view, but somehow it was unilaterally proposed and decided by council. And in this 99-437, when you look into the details, when it speaks about what is Schengen related, it says police cooperation and judicial cooperation as it existed in 99, and thereby implying that further developments in the field of judicial and cooperation, which go beyond mere cooperation but are based on mutual recognition, are not Schengen related. How well-founded was it to define it in that way? If one would have brought it to the Court of Justice again, I wonder how the Court of Justice would have decided. But now, I mean, it's a key, it's part of reality, we have to accept it, but just as an explanation. The concrete question on how Ireland and Cyprus could be then get potential new positions under reworked agreements, I think it's premature to speculate about the concrete details. First, I think it's because it's very easy to find 10 reasons why I think cannot work. The best what we could achieve maybe from this session is at least that we agree that we should sit down together and speak about possible scenarios and not yet single out the concrete way in which things could be done. On the international agreements, in the field of Schengen, we have in essence three types of international agreements: the visa facilitation, visa waiver, and readmission agreements. So the first two are formally Schengen Acquis. Readmission was labeled as not Schengen related, also for political reasons. Nevertheless, in all these three agreements, you normally find then annexed declarations in which the Schengen Associated States and not participating member states are encouraged to conclude parallel agreements. The current reality is, however, very, very complicated. It's so complicated that it's very difficult to understand. For instance, Denmark participates in a visa waiver agreement, but it does not participate in visa facilitation agreements. That's due to a specificity in the Schengen Protocol, in the Denmark Protocol. In the Denmark Protocol, it said that the visa list regulations, so which country is visa obliged or not, it was already communitarized in 95, and therefore Denmark continues to participate as a full member state. Therefore, Denmark also continues to participate in negotiations of a visa waiver agreement, which say whether you have to have a visa or not, as full member states. Whereas visa facilitation agreement, when it's about the modalities of participation, there the Danish opt-out is activated and Denmark does not participate. Tell me, who should understand this? So at least on these specificities, I think a renewed approach could at least make things less complicated. Not really clear-cut, but at least a little bit less complicated. And the same also goes what you said, Peter, on this option 2. Option 2 is in fact not one option. Option 2 could consist of many sub-options, how we could somehow in the future maybe try to be a bit more consistent in defining the Schengen Acquis. For instance, return. Maybe it's time to do away with this very weird concept of hybridity and really say that return is Schengen Acquis. Yes, because hybridity brings about a lot of legal problems. We need to speak about it. I'm not saying it's the right way, but at least we should speak about it. The same police cooperation, Prüm, for instance. If Prüm would have been labeled now as Schengen related, there would have been no need for Switzerland and Schengen Associated States to negotiate separately their involvement in Prüm. On the other hand, you can say, why should Schengen Associated States get this free gift of participating? So there are pros and cons. And again, when it's necessary to sit down and consider sine ira et studio.
So I don't know if Elisa or Peter would.
Perhaps just one addition on the situation of Cyprus. The difficulty with Cyprus is that for the Republic of Cyprus and for the European Union, the Republic of Cyprus territory is the whole of the island. So Protocol number 10 to the Act of Accession of 2004 says that in the part over which the government of the Republic of Cyprus has no control, which means the northern part, which has been occupied by Turkish army in 1974, EU law is suspended. So that is the background, which means that the Republic of Cyprus cannot, if it would want to do, it cannot exercise its full control over its external borders, which are the sea borders in the north, or an airport in the north. At the same time, the Green Line, which is the line, the ceasefire line of 1974, which is controlled by the United Nations military, there is a regulation where it says that the Republic of Cyprus must exercise at that Green Line external, controls equivalent to external border controls. It are not external border controls, but they are border controls which are in the same type of controls as if it were an external border. So if you see that situation, I think that it should be possible for Cyprus to join Schengen and to apply all measures, save the major point, as Junan Scooter said this morning, is Article 2.1. That is, the internal border controls between Republic of Cyprus and the rest should remain as they are now until this whole question, the Cyprus problem, is solved. It's not difficult to participate in the whole of Schengen and nevertheless keep border controls. Some member states do it from time to time. Yeah? It's of course the aim and the goal, but it can, for good reasons, be separated. So I don't think that for Cyprus is a real legal problem. The situation on the ground is a real problem, but it can be, I think, organized and probably simply on the basis of the protocol number 10 to the Act of Accession, which clearly defines the legal situation to EU law. Thank you.
And Elisa, I don't know if you'd like to add something.
Maybe just a comment on what the colleagues in the room said regarding the external relations and the geographical scope of the Justice Home Affairs and Schengen Acquis in case of the reform that were mentioned. I said in my presentation very briefly that Schengen is a success story for Switzerland and the Swiss-EU relations. Indeed, what we are trying right now also to make the whole architecture more coherent is to have other bilateral agreement with the EU in other area like PNR or ECRIS that supplement or complement the Schengen Acquis and help us to work better together. From an EU perspective and a Schengen area perspective, it's not even imaginable, at least for me, not to have Switzerland in this cooperation. It would mean to have a hole in the middle of Europe with systematic land border control, which has developed incredibly in the past years. So we cannot compare the situation back in 2004 with the situation today. With a gap in the security and migration cooperation. So I think when I said that the renegotiation and adaptation of the Schengen Association Agreement would be an adventure, I probably could have said a true nightmare from an internal political perspective, but I think the only bigger nightmare to that one would be an exclusion of Switzerland from the Schengen cooperation. So I remain positive that behind and despite all the complexity and challenges, there is a room for a Pareto improvement of the situation.
Thank you. So we have a little more time if there are any further questions, and I see from Julian.
Thank you. Well, it would help, of course, if Switzerland, Norway, and Iceland became members of the European Union. That would simplify matters a lot. Secondly, I read recently that the most recent poll in the United Kingdom is that now 60% of the United Kingdom population wants the UK to return to the European Union. Let's keep hoping. It's not for today, it's not for tomorrow, but perhaps for the day after tomorrow. And we have this interesting article in the Schengen Protocol to the treaties, which says, Article 7, for the purposes of the negotiations for the admission of new member states into the European Union, the Schengen Acquis and further measures taken by the institutions within the scope of the Acquis shall be regarded as an Acquis which must be accepted in full by all states candidates for admission. So if the UK wants to come back, no opt-outs on the Schengen Acquis. And if there is no opt-out for the UK on the Schengen Acquis, there is no reason for Ireland to be different. So there is my hope for simplification, Mr. Lutz. I think one day when you are probably retired, as I am, we will see this. We will see the sun shine again, and we will have no need anymore to define Schengen Acquis or not Schengen Acquis, Schengen related, not Schengen related, because everyone will be on board. Thank you.
At least my job is safe for the while. Sorry. So, and any other questions?
Unless you have remarks.
Well, one thing I was just mentioned just before was that if we look at the elements of complication, so we've identified perhaps four. One is the countries that would be excluded if you label something as Schengen. Sometimes the countries who would be excluded if you don't. So that's the opt-ins and the opt-outs. The third category, what you pointed out, was about the hybrid nature of instruments, which has caused its own headache, not least because then you have to assess in what way and to what extent it's hybrid, and there we can have, and sometimes do have, different views. And then you also have the two-step test. You know, the fact that even those for candidate countries, there's certain parts of the Schengen Acquis that will apply from the time of their accession, and then certain of the time that the rest will only apply when the Council decides unanimously to allow them in. And at the moment, at least since March, Croatia has joined, and we're still hoping that Bulgaria and Romania will be able to join soon. So I'm just wondering that if one looks at then these four types of complexity, okay, there's nothing we can change quickly about the ins and outs, but my first question would be, is it not important to, like, if you've got two sets of JHAs, you've got the JHA world and you have the Schengen world, and if you've got different groups of member states or different groups of states that can participate in each one, is it not a valid reflection to consider who will be in and who will be out? And the fact that if one, for example, interprets Schengen very broadly, then like Ireland may be out. If you interpret Ireland very broad, the Schengen restrictively, then Schengen Association would be out. So that's one question. But the other point is then, out of those 4 areas, is there one part you think where we could already resolve the complexity? For example, accession or the hybrid nature of instruments.
Sorry, Chair, there is a question online.
That's it, then it's even better. So let's, yeah.
Unless the person is gone, because she or he had to wait too long.
I'm sorry. Well, should we start and then if they want to? No, okay. Yeah. So do you have any thoughts on D?
Well, looking at the variable geometry, so if we assume that the participation of the largest possible group is a coherent application by a largest possible group is a good thing, then in principle the extension of the Schengen Acquis interpretation would be positive. Let's say, let's take the example Prüm. So if Prüm was labeled Schengen related, then Denmark could participate since it's a part of under the current protocols, and it would be a development of the Schengen Acquis where it could participate under international law. The Schengen Associated States would be they could directly participate because it's a Schengen Act and wouldn't have to conclude separate bilateral agreements. And for Ireland, there would be the option to request participation in this part of the Schengen Acquis if it is not yet already covered by the existing request to participate. So we would have a coverage of all member states for the moment if we follow this extended line in certain parts of the Schengen Acquis. Therefore, this would be personally my preferred approach. And yes, on the hybridity, I think we could relatively easily also clarify the issue. But again, it would require the necessary changes. But this is a thing where I think one could relatively easily obtain an agreement.
Great. Well, then we won't hold you for lunch, and just like to take this opportunity to thank very much Fabian, Lutz, and the panelists for their very thought-provoking contributions this morning.